Welcome. This is Aaron Miller at Lawyers with Purpose, and today we're going to discuss using Ipug's versus using LLCs for business clients. Using Ipug's, or irrevocable pure grantor trusts, can give a client greater flexibility, more privacy, and allows you to serve your clients in a whole new way. Irrevocable pure grantor trusts are irrevocable trusts where the grantor has a lot of rights. The grantor can be the trustee, they have limited benefits, possible access to income, although they don't have any access to principal, and they can change certain aspects of the trust whenever they want to. And the best part of it is the assets in the Ipug are asset protected. If you would like a more in-depth discussion of Ipugs, contact Molly Hall at mhall@lawyerswithpurpose.com and ask her for Dave Zampano's Law Review article. So how can we use the Ipugs for business owners? There are two basic strategies when using Ipug trusts. First is what we call the bubbles and boxes conversation. The second is using a single purpose Ipug. Let's start by looking at the bubbles and boxes. Let's say we have a client that created an Ipug trust. They are the grantor and the trustee. Now when you look at the client's world, they could own a home, stocks, a house, car, savings, and we're going to say that building here is a business. Let's say the client is running his or her business and something happens, so that somehow someone gets hurt because of the business. Everything the client owns is now subject to loss, subject to judgment. So how can we change that? Well, we could put a bubble around the business. That bubble is called an LLC or corporation. The LLC or corporation circles the business. When an owner puts an asset in an LLC or corporation, they have limited their liability to what the owner owns inside that bubble, which is just the business assets. But what happens if the client has one too many drinks and goes out and hits somebody? Then in that case, everything they own is then subject to liability, including the bubble. How do we fix that? The solution is to throw everything that you want to protect into the Ipug trust. Now we can't put everything they own in the trust because then we would make them insolvent, and we can't do that. We want to leave enough cash and savings in the revocable trust so that they can continue to meet their obligations. But this is the amount of assets that the client wants to leave at risk to creditors and predators. The other thing out there is the red hot rod. Inside the Ipug trust is the house, the stock, the savings, and the bubble with the business inside of it. Now when someone gets hurt at the business, just like when they had the bubble outside of the trust, they can't get outside the bubble to get at the other assets. So all the liability for the business is limited to what is inside the bubble, which is what we call asset protection from the inside out. But now, from the outside in, there is also asset protection because the business owner is the Ipug, not your client. And if the client goes and hits somebody with that red hot rod, the assets in the Ipug trust are now protected from lawsuit. Now, the only thing at risk to the liabilities of the grantor is the maximum amount of income that could be distributed out from the Ipug to the client. Now, while we're talking about income, there are two ways income could come out of this Ipug trust. First, we have interest or dividends from the savings and stock. The other is from the business. Inside that bubble, if there is income generated, it does not have to pay income it generates out to the client. You could keep the income in the bubble. So if we wanted to protect the income generated from the business, we could hold it until the danger is past, and then push it out of the bubble, into the box, out the trap door, and into the client's pocket. So once again, by putting the bubble in the Ipug, we have asset protection not only from the inside out, but also from the outside in. What about using a single-purpose Ipug? A single-purpose Ipug is a separate Ipug that has three general uses, and it is part of a larger estate plan with a master Ipug that controls the main asset distributions. The first use of a single-purpose Ipug is an Ipug with a single beneficiary. That is, when the client has a specific bequest to an individual that the client wants to be private or different than the distributions to everyone else. The client may say, I want something special for my niece Sharon, different than all my other nieces and nephews. I don't want her distributions to be mingled with everyone else, and I don't want the other nieces and nephews to know about it. If a client comes to you with that, then you could set up a single-purpose Ipug to deal with the distributions to Sharon, and use the master Ipug to deal with the other distributions. That way the single-purpose Ipug does not become part of the general trust administration, and there is no cross-disclosure. The general beneficiaries of the master IPUG don't have to be aware of the single-purpose IPUG, which is then kept separate and private from everyone else. The second use could be where you have a single asset. This could be a business, which we're going to be discussing in detail in just a minute, or it could be a piece of real estate that the client wants to manage separately or differently than all the rest. The third use is where you have a single goal the client wants to accomplish during the client's lifetime, or for a certain period of time or purpose after the client's death. Maybe the client wants to set up a fund to make sure his fraternal brothers can get together once a month for dinner and remember him after he dies. Or maybe the client wants to have all the family get together once a year for a family reunion. Sometimes you can merge goals and assets, such as taking a camp property, which is a single asset, and setting it up so that the family can use it after the client is gone, which is a single goal. Maybe mom and dad bought some property that is so appreciated that no one in the family could afford to take it because of the taxes. The client could put the property into a single-use IPUG, but make provisions so all the family could continue to enjoy it. Now, let's take a look at comparing an LLC or corporation with a single-purpose IPUG. An LLC is a separate legal entity, and so is a single-purpose IPUG. We know that an LLC or corporation can own assets. Again, so can a single-purpose IPUG. An LLC or corporation has owners, and those are typically referred to as members or shareholders. A single-purpose IPUG has a grantor. The grantor is the owner for purposes of an IPUG strategy. The LLC or corporation has a manager or CEO. The single-purpose IPUG has a trustee, and just like the same person can own and run a business with an LLC or corporation, the same person can be both the grantor and trustee for a single-purpose IPUG. How the LLC or corporation is taxed, whether separate or not, depends on the tax election the client makes. There are three ways it could be treated. First is the sole proprietorship, but that is only as a single-member LLC or corporation. This would be filed on the client's 1040 Schedule C. If there are multiple owners, the LLC or corporation could be treated as either a partnership or corporation for tax purposes. If the client elects partnership status, that would mean a separate partnership tax return would be prepared, a 1065, and K-1s would be issued to the owners as to their pro rata share. If the client elected corporation tax status, then the corporation would file on Form 1120. Now, we won't get into the distinctions between the C or S corporations today. So an LLC or corporation could be a separate taxpayer, or it could show up on the owner's 1040. It just depends on the election that the owner did. With the single-purpose IPUG, there is no separate taxpayer. It is all on the grantor's 1040 Schedule C, as if the grantor owned the business directly. The LLC or corporation has an operating agreement, which directs how things work within the LLC or corporation. The single-purpose IPUG has the trust terms. The operating agreement will identify who receives profits and how they are to be distributed. The trust terms identifies the beneficiaries and how the distributions are to be made, both distributions of income and distributions of principal. You don't have distributions of principal under the operating agreement generally, or if you do, it's to all the owners equally. But in trust terms, you can be very flexible in how you treat each beneficiary. Under the operating agreement, it appoints the members or shareholders, and the members appoint the CEO or manager. Under the trust terms, the grantor can appoint or remove trustees just like the owners or members of an LLC or corporation can appoint or remove the CEO. In the operating agreement, member powers are identified. In the trust terms, the grantor retains all powers. The grantor can change all the beneficiaries, change the time and manner of distribution. They can change anything except what they are trying to protect, which is always the right to the principal in order to get the asset protection. But they retain all powers to hire trustees, fire trustees, change beneficial interests, and change anything in between. The operating agreement can be modified with consent of the owners or classes of owners. Under the trust terms, it is modified by the grantor and the limited power of appointment has been retained. The LLC or corporation has a board of directors. The single-purpose IPUG has a trust protector. They work identically. The LLC or corporation has inside and outside tax basis. First is what is the basis of the owner in the corporation or LLC itself. That is the outside tax basis. And then look at what is the basis that the LLC or corporation has in the assets that it owns. That is the inside basis. In a single-purpose IPUG, there is no inside tax basis. It is outside basis only. LLC corporations have no step-up in basis of assets owned by the LLC or corporation at the owner's death. But there is full step-up in basis of the assets in the IPUG at the grantor's death. So let's take a look at a case study where a real client of Davis & Pono's law firm could have gone with an LLC, but instead chose to use a single-purpose IPUG in his planning. Of course, we've changed the names to protect the confidentiality of the client. Phil and Carol were 72 and 69 years old. They had 4 kids. Phil Jr. and Mark both work in the family business, while Matthew and Mary do not. There are 28 pieces of real estate. Some are corporate, which are owned and used in the family business. Some are commercial pieces that were rented out to individual businesses, and some personal real estate rented out to individual families. The client's goals were to protect the assets of the 4 kids, and they didn't want anyone else to have any access to it. Not the kids' spouses, not creditors, not nursing homes, or anyone else. Phil and Carol wanted to make sure that they were both provided for, and they had a few specific bequests that they wanted to make sure was also included. And most importantly, they wanted to protect the assets from Phil and Carol's future long-term care needs. In this fact pattern, we did the traditional estate plan audit, which is how we at LWP figure out what the client's goals are, what's important to them in their world. You can see here under number 5, provide asset protection for your spouse after your death. They have a 10. This is very important to them. Under 6, provide for protection of assets if your spouse remarries. That is a 10. Under 7, it says protect assets for children or beneficiaries for their lives. The client said this was a 10 plus. Number 14, provide asset protection during your lifetime. That's a 10. You can see asset protection for these clients is very, very important. So this client was ready to go right away, but Dave said, listen, let's do the master plan first, the master IPUG, and then when we're funding, we can decide whether you want to do LLCs or single-purpose IPUGs. So what's this look like on paper? At the funding meeting, Dave first showed them what they had right then. You can see the house with the different real estate. Some of them were already in bubbles. Some were owned individually. They had a car. They had stock. Some property was owned by the corporation, and then they had the business itself. Remember, they had already created the master IPUG at this point, which is the family trust at the top right. Then they had to decide, are they going to put them in a box, or are they going to put multiple bubbles to put the real estate in? This is the diagram that was done at the end of the meeting. Dave suggested that they create a Franklin Trust and a Lake Trust. They would take some properties and put it directly in the Franklin Trust. They would take some other properties and put them in the corporation inside the Franklin Trust, and then they would put other property in the Lake Trust. The Franklin Trust and Lake Trust were both single-purpose IPUGs. Again, the Family Trust was the master IPUG. In the master IPUG, at the second death, there are separate trusts created for each of the kids. You can also see that from the Franklin Trust, which is where all the business assets were going, it goes to Phil Jr. and Mark's separate share trusts. So Phil Jr. and Mark can decide when to dissolve the Franklin Trust after Phil and Carol are gone. And when they do dissolve that trust, it will go over to Phil Jr. and Mark's separate share trusts. In the meantime, they can manage it separately from all the other assets and from all the other beneficiaries. Now, while Phil and Carol are alive, they get the right to the income off the family trust because it is an income-only trust. The clients can still get the income from the business, but they are no longer managing the business or any of the assets because they've made their 2 sons the trustees to manage everything related to the business in that Franklin Trust. The bubble is the corporation, so they can pay Mark and Phil Jr. directly as a salary, or the income can go back out through the family trust and back to Phil and Carol. Now the Lake Trust just collects rent, and that goes back to the grantors, Phil and Carol, during their lifetime. The Lake Trust does not terminate when Phil and Carol pass away, so the rent that's paid at that point will then go into the children's separate share trusts. So as you can see, the conversation really comes down to funding. You can either put the real estate in the bubbles and put the bubbles in the boxes, or you can put real estate into single-purpose Ipugs. So what did Phil and Carol decide to do? Well, they chose single-purpose Ipugs. Why? Likely a lot of the same reasons that your clients would probably do the same. Clients love single-purpose Ipugs. Why? First, Phil and Carol hated getting inundated with mail from people who watched those LLC and corporation filings. Second, Phil and Carol hated having to pay for the annual fee for the corporation or LLCs. They felt that this was a separate hidden tax on them. Third, Phil and Carol didn't like having to file separate income tax returns. It was complicated and confusing. Fourth, they really liked the privacy of the trusts and didn't like having to disclose everything that the state would require them to do with an LLC or corporation. Fifth, Phil and Carol were able to separate assets to achieve different goals without disclosing it to all the other beneficiaries. And finally, they were able to get a full step-up in basis of the assets in the trust at death. What are some of the other advantages of doing a single-purpose Ipug? You can plan and name successors, or you can create formulas for successors. You can plan for results rather than just operations. A single-purpose Ipug is easily integrated into an overall plan. The client can maintain control as trustee or as trust protector, and a single-purpose Ipug is tax neutral and simple for clients. So these are all reasons why a client might pick a single-purpose Ipug. To learn more about Ipugs, we offer a unique 3-day live in-room program that we call Practice with Purpose. This program not only gives you legal technical training on wills and trusts, Medicaid, and VA, it also gives you marketing and practice management training. Seating is very limited to these events. If you would like to reserve your seat now, email Molly Hall at mhall@lawyerswithpurpose.com or call her at 877-299-0326, extension 102. Thank you very much for joining us today.